So someone commented on my Ladybird deed video, my most recent Ladybird deed video, asking if you can do a Ladybird deed when there's a mortgage on the property. So the answer to that question, the original comment, is yes, you can definitely still get a Ladybird deed in place when there's a mortgage on the property. The mortgage, if it's not paid off upon your passing and it gets inherited by the beneficiary on the deed, then they do have to assume the mortgage or pay it off or potentially refinance depending on the situation. However, I wanted to take up this comment, which was a comment after her comment, I guess, and trying to answer the question about whether you can have a mortgage and still get a Ladybird deed in place. And this person wrote, your lender can call the note due if you modify the deed. Just put the property into a trust. So putting the property into the trust is definitely also a modification of the deed. Whereas a Ladybird deed really isn't a modification in the sense that the lender's going to call the loan due, because with a Ladybird deed, you're not actually changing owners of the property, which is when a lender would call a loan due or potentially call a loan due. It's when a lender has lent a specific person or people money, or lent money under a trust or an LLC, whatever the scenario is, and now you're changing ownership to another individual or individuals or a trust or an LLC. That wasn't the original party that they lent the money to. So when you change the name of the person who's on the title, if the lender has an issue with it, they don't always, but they always have a clause in their agreement that allows them to call the loan due. When you put a home into a trust, you are changing it from your name into the trust's name. So that scenario is more likely to get a loan to be called due than utilizing a Ladybird deed, which simply allows you to keep the original owners on the deed, but then list beneficiaries who can inherit the property after you pass away. As far as lenders are concerned, I'm gonna, put this out there that depending on the bank and depending on their understanding of the various types of deeds, they really shouldn't call a loan due if you're putting property into a revocable trust or you're utilizing a Ladybird deed. In either of those scenarios, that shouldn't happen. However, individual lenders have their own internal policies. Some understand these types of deeds better than others. So I'm not going to sit here and say there's zero chance that any lender is, not going to mistake what a Ladybird deed is, just like they could easily mistake why somebody might be putting property into a revocable or revocable trust, right? So it's really about the individual lender, but the point that I'm trying to hit home here is you're not modifying the owner of the property when you do a Ladybird deed. You are remaining the owner throughout the rest of your lifetime. And the reason you want legal counsel to prepare this deed is it's really clear on the face of the deed that the person who you list as your beneficiary, or if you're listing a trust as your beneficiary, you yourself maintain you're the only one who maintains the option to either lease the property, sell the property, take out a mortgage on the property. You don't need anyone else's permission. You're still very much in control and calling all the shots. Nobody else needs to sign off on anything. Everything still stays with you. Ownership is still vested 100% in you, the original owner of the property, which is why I've actually seen the opposite a lot in my practice, where I see more people run into issues with lenders when they're moving property into a trust than if they're utilizing a Ladybird deed. That being said, I have seen weird things with refinances in particular, whether there's a Ladybird deed in place or a home had already been moved into a revocable trust. I have seen lenders in that instance make the person take the property out of the revocable trust, or switch the ladybird deed back to where it's not actually a ladybird deed anymore in order for the refinance to go through, and then you can switch it back to how it was. So I've seen all strange types of things with lending, so nothing is going to really surprise me here, but I did want to make sure this point was clarified, that the ladybird deed, you're not changing ownership, much less likely in most normal scenarios for a loan to be called due, versus a trust, which you are changing ownership. And again, remember, when you change the actual owner of the property, it also affects the title insurance too, because the title insurance follows the original owners who purchased the title insurance. All right, so I hope this clarifies things, and I hope it also answered the original comment that, can you get a ladybird deed in place when there's a mortgage? Yes, you can. You can definitely do that. If you have any other questions regarding ladybird deeds, estate planning, probate, or Medicaid, please don't hesitate to contact our office or atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.